here with all of your quick political news and headlines to get your day started right. And this morning, we are discussing what's on the ballot with Miranda Yaver. She is a postdoctoral scholar at UCLA. She is an expert of constitutional law and public health policy, and I'm so pleased she's joining me this morning. Welcome to the program, Miranda.
Thanks so much for having me, Alex.
Well, first and foremost, right off the bat, last week was a week ago today, although it feels like a year now, was the passing of Supreme Court Justice Ruth Bader Ginsburg, who passed away at 87 years old from a long bout with pancreatic cancer. And her death is being mourned and at the same time has really upended the 2020 presidential election. It's really raised the stakes because of what the implications may be for the Supreme Court, with Donald Trump and Senate Majority Leader Mitch McConnell making clear their intention to railroad through a nominee before Election Day. So will you talk to us a little bit about what this vacancy on the Supreme Court means for policy and politically?
Yeah, absolutely. So, Ruth Bader Ginsburg, I'm assuming that most of our viewers know, was a force to be reckoned with on the Supreme Court. She was one of the two most liberal justices, she and Justice Sotomayor. She was the architect of the jurisprudence on gender and equal protection. And so, for people who study constitutional law, it's been a real frustration that we haven't even really been able to mourn her loss, and it's just been leaping right into the politics and policy. But obviously, this is huge, just monumental shakeup on the Supreme Court. And so, between the fact that Justice Kavanaugh replaced Justice Kennedy, and the fact that Ruth Bader Ginsburg is going to be replaced by a Trump nominee, those are two really significant areas where we're seeing the median of the court shift, where Neil Gorsuch is now going to be the swing justice, or the median on the Supreme Court, which is something that's going to keep me up at night for a while. There were a number of areas where Anthony Kennedy was quite conservative, but abortion and affirmative action were not among them. So I think that what we're going to see is three areas that we really need to keep our eyes on are healthcare. The Trump administration is arguing before the Supreme Court on November 10th that the entire Affordable Care Act should be held unconstitutional and thrown out. Reproductive rights, obviously, we no longer have five. I shouldn't say obviously, but we'll probably no longer have five justices who believe that Roe v. Wade should be preserved in its current state. And third of all, affirmative action, where Justice Kennedy typically sided with the more progressive types in saying that race was an acceptable consideration in hiring or education, as long as it was one of many factors. But healthcare and reproductive rights are obviously two things that are going to come up a lot in the confirmation hearing and that affect a huge swath of the American public.
Yeah, I think what people should know, it's important to note, is that this would create a 6-3 conservative to liberal split on the Supreme Court. It will reshape the Supreme Court for an entire generation.
Probably more than a generation.
Right, and we know that the front runner for the nomination, what we're hearing is Amy Coney Barrett, who has spoken out quite strongly against Roe v. Wade. She also is an originalist, so she believes that the Constitution should be interpreted with the vision of the original drafters and in that time period. So people, LGBTQ people, women, people of color, they're all jeopardized by a Supreme Court pick who believes in an originalist interpretation of the Constitution.
Originalism and less the corporations' rights are at stake is what I like to joke.
100%. And I think, when we look at her views on Roe v. Wade and LGBTQ rights. They're very troubling. So with that new super conservative majority, a lot of these issues that you're talking about that are really fundamental social protections will be lost.
Mhm.
So here in California, we're a pretty progressive state when it comes to policy, although there is still some work to do. There is a ballot initiative coming up in this November's election that would repeal a previous repeal an end to. Am I saying this correctly? Affirmative
Yeah.
action. It's a repeal of a pro-affirmative action piece of legislation from the 1990s. Did I get that right?
So it's a repeal of an anti-affirmative action. So
Perfect.
it's tough because
Thank you.
it's a double negative.
It's
Yeah.
still early. It was a double negative, and I
It's
thought it
a,
should be.
I don't think we should have double negatives before 8 a.m. But yeah, so in 1996, California passed a proposition called Prop 209. And what that did was it said that in public public employment, public contracting, public education, you can no longer have race as a consideration. And it's important to note that this was a deviation from what the Supreme Court had said that they could do, because in UC Regents v. Bakke, a 1978 Supreme Court decision, as long as race was part of a holistic review, and there weren't quotas, I should say, explicitly outlawed quotas, but didn't outlaw affirmative action. That was essentially what the Supreme Court had said in 1978. Then in 2003, the Supreme Court said, well, race can actually be one of many factors. You can't be admitted because you're a person of color, but it can be part of the sort of many ways of diversity that you might contribute to a campus education. And so it's not so affirmative action has been upheld by the Supreme Court to at least some degree on a number of cases, but they haven't been wild majorities. These are not 9-0 cases. These are 5-4, 6. These are generally like 6-3 decisions. So with Prop 209, it said you can't use race in these considerations, and the diversity in the University of California student body really went down. I saw one estimate that I think it was like a 12 percentage point decline in Black and Hispanic enrollment, and that's non-trivial. So one of the things it's what the Prop 16 on this ballot, Prop 16 is doing is it's saying we want to get rid of Prop 209. We want to be able to restore race as one of many considerations in university admissions. The problem is that both Anthony Kennedy and Ruth Bader Ginsburg favored affirmative action, while other justices on the court's conservative wing don't so much, and we don't know we don't know for sure who's going to be on the Supreme Court, but we can say that whatever California votes on Prop 16 could still be endangered by what the Supreme Court does when it most assuredly comes before the court.
I think to chime in on that, I think important for our viewers to know the concept of preemption, which is the constitutional ideology or constitutional viewpoint that the federal government's law will preempt the states. So a lot of people in California who feel like, oh, we may be protected from some of the more draconian new rulings that will come out of this scary new Supreme Court. Will be protected here in California. I think it's important to know that with cases like anti-Roe v. Wade or anti-affirmative action cases that might come before the Supreme Court, they will preempt any state law that protects those things here in California.
Well, that's true to some extent, but not entirely. So with affirmative action, this is going to be a case that comes down to the 14th Amendment. Is this discriminating against people on the basis of race? With respect to Roe v. Wade in healthcare, some states have what's called trigger laws, which say that if this act is struck down, this state is going to have its own laws on healthcare, or abortion rights that are going to be protected. Because what's different between the affirmative action and healthcare and healthcare or reproductive or abortion rights is that with affirmative action, they're saying it's discrimination based on race, it's discrimination based on white people, essentially. And there's usually not a whole lot of talk about white affirmative action, which is legacy admissions. But with Roe v. Wade, what it was essentially saying is that there is no federal protected right, and it's only just going to be this patchwork system statewide. So it's true that California would not be protected if there's an affirmative action ruling that goes against it. But blue states like California or New York have taken action to ensure that they would be protected in the event of an anti-Roe v. Wade decision, for example. I think I lost Alex. While we're waiting for Alex to get back, does anyone have any questions about affirmative action or Roe v. Wade or the Supreme Court?
Miranda. So we're talking about these concepts about preemption in the federal government.
Yeah.
And I think really also let's add that the new potential Supreme Court Justice Amy Coney Barrett doesn't believe in precedent. She believes that judges can override precedent if they believe that the previous rulings were found to have been erroneous or imperfect. So with that, that may be some of the justification that the new Supreme Court has for overturning very important social protections. So what's the importance of passing initiatives like the pro-affirmative action repeal of 209 that's coming up on the ballot this November for Americans who are concerned about losing these kinds of civil protections?
Yeah, so one thing that I want to mention since you talked about precedent is, the reason that we have precedent is so that we can build stability in law, so that we're not constantly seesawing between interpretations. Congress is supposed to be the body that's really hyper responsive and they can change its mind more often. But we want more stability in law. Amy Coney Barrett is not wrong in saying that they can overturn precedent if a precedent is wrong. But having someone who is so explicitly talking about that does suggest that she wouldn't have any hesitation about throwing out a very recent affirmative action decision, which was Fisher v. UT Austin. The reason why continuing to pass these kinds of ballot measures can be meaningful is it can show public support for an issue. And so when we talk about, so it's not so that we can show the Supreme Court that while it certainly doesn't have to follow public opinion, we can show that there is not only a theoretical justification, but also broad public support for an issue. And at the end of the day, the Supreme Court isn't involved in the enforcement of its decisions. Alexander Hamilton said in Federalist 78 that the Supreme Court has neither the sword nor the purse and only judgment, and viewed the Supreme Court as the weakest branch. Now, I'm not sure that I agree with the Supreme Court as being the weakest branch, but it is true that it depends on others for its implementation. And when the public is showing broad support for things like reproductive rights, for health care, for affirmative action, not only does that send a signal to the Supreme Court that there could be a real backlash, but it can also send a signal that members of Congress could potentially be responsive to that opinion and do things that might limit the scope of those rulings.
Brandon, we have a question from you from a viewer. I'm not sure I understand the question, but maybe you might. It's asking, can you explain the difference between Roe and affirmative action and states' rights again?
In terms of what the states can do. So what Roe v. Wade did was it said that there was a federally protected right to abortion within the first trimester, but then later on, the states' rights change. The state's interest in life versus potential life changes. Now, the really controlling Supreme Court decision that we want to think about with abortion is actually not Roe v. Wade. It's a 1992 decision called Planned Parenthood v.
Parenthood,
Casey.
right?
And what Planned Parenthood v. Casey did was it said, well, abortion is protected. Roe v. Wade we're going to uphold, but states can actually enact their own restrictions as long as they don't pose an undue burden. Now, because the Supreme Court didn't want to make things easy for us, they didn't actually define what an undue burden was. So it's kind of in the eye of the beholder. But what that essentially did was it reaffirmed, yes, the woman has some right to terminate a pregnancy, but you can have to go through some hoops to get there. But ultimately, what the pre-Roe v. Wade, but what is important to think about is, so there's a lot of state variation in abortion access. But what's important to note that the pre-Roe v. Wade world was not abortion is illegal everywhere. It was that there was no federally asserted right to an abortion. And so there were some states where it was legal and a lot of states where it wasn't. And so that's what I meant when I said that going to the pre-Roe v. Wade world doesn't mean that it's explicitly outlawed. It just means that there isn't a federal protection. So basically it's going to mean it matters a lot which state you live in. Whereas with affirmative action, the Supreme Court is going to be doing a constitutional interpretation saying whether affirmative action violates the Equal Protection Clause, which is in the 14th Amendment. And if the Supreme Court says that race-based considerations violates the 14th Amendment, that's it. That's the game, and that's going to apply everywhere. I hope that makes sense.
Right. Thank you so much, Miranda. I'd like to thank our guest, Miranda Yaver. She's a postdoctoral scholar at UCLA, an expert of constitutional and public health policy. Where can people find you, Miranda, if they want to engage with you a little further about some of these issues?
Yeah, you can find me on Twitter at Miranda Yaver. I'd love to hear from you, and feel free to reach out.
And I do. I tweet her every once in a while because it's a good
I enjoy
chat.
it.
Adam Cobb says, "Go Bruins," and thanks, Miranda.
Go Bruins. Yes,
Hey, go
absolutely.
Bears. You know, Bruins are just Bears with lower GPAs. You know that, right?
Well, the Bruins actually outrank Berkeley right now, but yeah.
Enough of your attitude. This has been the AM Report with Alex Mahajer for Haps News, the network of Now. We are live every weekday morning at 7:30 a.m. Pacific, 10:30 Eastern, with all of your quick political news and headlines. We'll be back next week. Thank you, Miranda, and have a great day.